President.
Senator from Indiana.
Madam President, I ask for the initiation of the quorum call.
Without objection.
Madam President, I rise today to call upon the President of the United States to overturn one of the most radical and unconstitutional mandates ever issued, a mandate that requires faith-based organizations and hospitals, educational institutions to provide and pay for health insurance coverage that violates the fundamental tenets of their faith. Our founding fathers believed so deeply in the importance of religious freedom that they made it the very first American principle in the Bill of Rights. The First Amendment to the United States Constitution reads in part, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof." On January 20th, the Obama administration announced one of the greatest deviations from this constitutional guarantee of religious freedom in our nation's history. The federal rule under President Obama is a blatant assault on the conscience rights of any organization or any individual that opposes abortion or the use of contraceptives. While I am a pro-life senator and believe that life begins at conception, I am not someone that supports banning contraception. But I do support the right of those who hold to that belief that those tenets should be respected and that federal mandates and federal regulations and federal laws should not be used to overturn that principal belief. I don't believe this was an oversight. The Obama administration doubled down on its ruling by ignoring the numerous efforts by faith-based organizations to be granted an exemption. This issue is not a debate over whether the use of contraceptives is right or wrong. This is not a debate over whether the health care law is the right policy or the wrong policy. I do believe, personally, that the Obamacare policy is the wrong policy for this nation. But this is a debate over whether Congress is going to sit idly by and watch the administration walk all over the freedom of religion, and not just the Congress, but the institutions of America and the people of America, a core American principle. Or will we stand up and protect what our founding fathers put their lives on the line for and what millions of Americans defend each day? Catholic institutions, whether they be Catholic social service in all of its forms, whether it be universities like the University of Notre Dame in South Bend, will have one of two choices. First, they can either pay for health insurance that covers things like sterilization or birth control despite their deeply held religious objections, or they can refuse to offer any sort of health insurance to their employees, which will result in these organizations facing significant fines and penalties while their employees must seek health insurance elsewhere. In other words, the Obama administration is saying, compromise your religious beliefs to comply with our massive federal health care law, or you and your employees will face a penalty. While this decision will greatly impact many in the Catholic faith, it will also extend beyond a singular religious denomination. A wide variety of religious institutions and organizations across the country will resist providing insurance coverage for birth control. Cardinal-designate Timothy Dolan, president of the U.S. Conference of Catholic Bishops, said, and I quote, "Never before has the federal government forced individuals and organizations to go out into the marketplace and buy a product that violates their conscience. This shouldn't happen in a land where free exercise of religion ranks first in the Bill of Rights." Although the most blatant violation of the First Amendment, this ruling is a culmination of attacks on religious and faith-based organizations by this administration. I fear, as Washington Post columnist Michael Gerson noted in his article today, that such a trend will threaten the good work being done by faith-based groups of any faith, whether it be Catholic or Protestant, whether it be Jewish or Muslim, any group or nonprofit, hospital or charity that is working to provide services to people in need now have to compromise their basic religious tenets in order to continue to provide that insurance coverage for their employees or pay a fine by not doing so. There have been some bills introduced here to overturn this. I would hope that those in the administration who are listening to the people and listening to the protest that is being made against this almost unconscionable mandate will not stand by idly and wait to see whether or not Congress will act, because we will act, and we'll act as soon as we can. I would hope that they would reconsider this sweeping, unconstitutional authority, which is in direct violation of the First Amendment. George Washington once said, "Every man conducting himself as a good citizen and being accountable to God alone for his religious opinions ought to be protected in worshiping the deity according to the dictates of his own conscience." We must take a stand to protect this inalienable right, the right of conscience, established by our founding fathers and sustained for over 200 years. Mr. President, you can undo this wrong by rejecting and overturning this mandate that has been imposed, which violates the most basic of human rights and principles of our Constitution, and I'm calling on you to do so. With that, Madam President, I yield the floor.
Madam President,
The Senator from Arkansas.
I ask unanimous consent that the order for the quorum call be rescinded.
The Senate is not in a quorum call.
Well, I ask permission to speak then.
The Senator from Arkansas.
Thank you, Madam President. I come to the floor today to add my voice in opposition to President Obama's unwillingness to respect the conscience rights of religious institutions. On January 20th, the Department of Health and Human Services issued a mandate requiring almost all private health insurance policies, including those issued by religious institutions, to cover free sterilizations and contraceptives at no cost to policyholders. What this means in simple terms is that churches are exempt from the mandate, but institutions such as church-run universities, hospitals, and nonprofits must comply with the government regulation. Therefore, in order to continue to operate, these church-run institutions must violate the very beliefs that inspire them to care for the least among us. I would not be surprised to see many of these faith-based institutions disappear should this mandate move forward. Despite the President's contentions that this outcome is not what he intends, his mandate unfairly forces people to choose between their health and their morals or religious values. Many parents, Christians, and others object to sterilization, agents that abort, and contraceptives. Americans should not have to pay for services or health care plans that conflict with their deeply held religious beliefs. This is purely a political decision on the part of the administration, and it shows that President Obama will do whatever necessary to appease his base and protect his own job, even if it means a blatant infringement on First Amendment rights. With this mandate, President Obama is not only trampling religious liberties, but he's also confirming what many feared when this health care bill became law. Americans saw this massive expansion of government as a threat to individual rights. This mandate, one of the first based on the President's health care bill, does little to comfort those concerns. In fact, it comes across as confirmation that the President intends to force on us his belief that he knows what is best for Americans when it comes to our health care choices. In an effort to fight the administration's overreach, I've joined with several of my colleagues in supporting legislation to protect freedom of conscience and prohibit the government from imposing mandates on our religious employers. Religious institutions play a critical role in our communities. If federal policies make it difficult for those institutions to continue important social services without going against their principles, it will hurt the least fortunate among us by threatening the much-needed assistance and outreach provided by religious groups across the nation. The seemingly endless number of regulations that this administration has handed down to the American people needs to end. Let's force the President to govern in a manner that respects the values of the American people, not just his base. Protecting religious organizations from this overreaching mandate is certainly an excellent place to start. I yield the floor.
Madam President.
Senator from Kansas.
Madam President, thank you very much. I'm here today to raise once again a topic about how we raise our youth, how we raise our children in rural America. And I want to talk about, just for a few moments, about the proposed Department of Labor child farm labor rules. Last week, we had perhaps what would be considered a piece of good news. The Department of Labor announced that they would withdraw and repropose the parental exemption portion of their proposed child labor rules. I'm worried, however, despite this good news, there is still a lot of effect that will occur, a lot of consequences that will occur as a result of the rules that are not proposed rules that are not being withdrawn, and there is no suggestion that they're going to be reproposed. And so the thing I want to make clear to my colleagues is that while the Department of Labor announced that they were going to withdraw a portion of the rules, unfortunately, the majority of what is going to be offensive, difficult, and a challenge for our way of life in rural America remains. Last year, the Department of Labor proposed a set of rules on their own volition, no direction by Congress, to put in place restrictions upon a person's ability to work on a farm and restrictions upon a young person's ability to work on a farm, including their own family's farm. And what we're talking about here is youth less than 16 years of age. And those rules as proposed would actually restrict the ability of a person, a son or daughter, to work on their parent's farm. The current exemption is that if your parents own a substantial interest of that farming operation, you can work on your family's farm. The proposed rules as of just a few weeks ago said that they would restrict that definition, and it had to be something more than your parents. The current law says, the current rules say that if your parents have a substantial interest in a farm, you can work on that farm. The rules were, as proposed, said that we're going to narrow that definition. If your family operates in a family farming corporation or a limited liability company, these new restrictions would apply. Fortunately, that portion of the proposed rules the Department of Labor has withdrawn, and I assume will be reproposing what their definition of a family farm is. The point I want to make is that so much of the proposed rules yet remain. The remaining portions of the rules still threaten to fundamentally alter agriculture as we know it today. If the DOL rules as now proposed go forward as they currently stand, the education and training for the next generation of farmers and ranchers will be severely disrupted. We've relied upon 4-H, FFA, county extension programs to provide farm safety training and certification for a long time, but the Department of Labor now says they no longer want those programs to qualify because they are too local. They want a national standard and want to replace with a Department of Labor program, safety training program, replace what has traditionally and very effectively occurred through 4-H, FFA, and county extension programs. The Department has, in my view, ignored research that shows the programs that we currently have in place with FFA and 4-H and extension improve the safety habits of young people, and instead criticizes these training programs for being too locally driven and lacking federal direction. Their solution is to nationalize these programs and have them run by the United States Department of Labor. In my view, local experts in our high schools, our FFA programs, our 4-H clubs should be the ones who are conducting training programs and educate our young people. And parents and communities should be allowed to look after the best interest of their families and their community's citizens. The Department of Labor, in addition to attacking the programs that are in place that are valuable to us in rural America, is also proposing to change the so-called agricultural hazard occupations. The proposed rules would prohibit a young person under the age of 16 from participating, even with the certification and safety training from the Department of Labor. They would be prohibited from doing such things as rounding up cattle on horseback, operating a tractor. The rules, proposed rules, say that you cannot be involved in production agriculture if you're more than 6 feet off the ground. Well, in today's environment, in today's agriculture, tractors and combines are 6 feet off the ground. Can't clean out a stall with a shovel and a wheelbarrow. Those are things that I'm sure maybe the 15-year-old doesn't want to do, but they are things that are important to a family's farming operation. They're important to agriculture, and of value to a young person in their training and developing skills that are important to them for the rest of their life. Can't work in a pen with a bull or mama cow. And here's one that really stands out to me. No engaging or assisting in animal husbandry that, quote, inflicts pain upon the animal, such as branding, breeding, dehorning, vaccinating, castrating, or treating sick animals. The inflicting pain sounds to me much more like something different than an interest. Inflicting pain upon an animal sounds like a different standard than really worrying about the young person's safety. These are important tasks that have to be done on a farm and that young people can safely do. One additional example that stands out to me is that they are suggesting in the rules that they would limit a young person's exposure to direct sunlight if the temperature reaches a certain limit once you factor in wind velocity and humidity. How does that work in the practical world of agriculture and farming today? For someone in Washington, D.C. to propose rules that restrict a young person's ability to work on a neighbor's farm because of the amount of sunlight, wind velocity, and humidity is something that, again, in my view, demonstrates a lack of understanding about how things work in the real world. One would assume that the Department of Labor, before making such drastic changes to farm labor rules, they would have identify reliable evidence and data to show the need for changes. In fact, the Department of Labor admits that it lacks the data to justify many of its suggested changes. And furthermore, according to the National Farm Medicine Center, youth-related injuries from farm accidents have declined nearly 60% from 1998 to 2009. I have no doubt if you ask a farmer or a rancher about the importance of safety, they would tell you that safety is a top concern, especially when they're dealing with a young person. But they would also tell you that it is critical to a rural way of life in being able to train and encourage the next generation to safely and successfully pursue careers in agriculture. If today's young person is not given the chance to learn at a young age what it takes to operate a farm, we put at risk the future of agriculture in our nation. I've always had a strong interest in agriculture. My state of Kansas its economy revolves in many ways about the success of farmers and ranchers. And the ability of communities across our state is dependent upon the success, the profitability of production agriculture. But I also have known and strongly believe that there is something more than just economics to family farms. This is the way that historically in our country, in our nation's history, we have transmitted our character, our values, our integrity, our love of life, our understanding of how things work from generation to generation. And it's worked. It's been an important component of our country's history, who we are as American people. Today across Kansas, when I visit with a business owner, they will tell me they love to hire farm kids because they have a different characteristic, a different makeup, a standard that is different than other people. They learn something about reliability and that work doesn't get done if you don't show up. And it's not about punching the clock to check in and to check out. That agriculture, that a calf is born at times that are inconvenient to the farmer. There's just a different set of characteristics that a young person develops by growing up and working on a family farm. If these changes go into effect, and the rule as proposed is being considered and expected that we will have an answer within several months from the Department of Labor as to what the final regulations will be. But if these rules go into effect as they are written, not only will we see a shrinking rural workforce, our nation's youth will be deprived of valuable career training opportunities, and a certain way of life that many of us highly value will disappear. It is important to us as a country, certainly to a state like mine, that a young person experience the value of farming. I don't know how many times you talk to somebody who's determined what their career is going to be based upon an experience that they had as a young person, and their ability to know what they want to do with their life is determined by the experiences they have as a young child. Our country cannot afford to lose the next generation of farmers and ranchers, and this rule should be withdrawn in its entirety. We know that rural America's values are not always Washington values, and in the weeks ahead I would ask my colleagues and Americans across the country to express their opposition to the Department of Labor for this destructive rule. Don't allow it to move forward so that we can protect our values for the next generation of American farmers and make sure that rural America remains a great place to live, grow, and raise a family. I yield the floor.
The senator from Mississippi.
Madam President, I'm pleased to rise in the Senate today and congratulate Eli Manning and the New York Giants football team for their great victory in the National Football League championship game. As most senators probably know, Eli is a graduate of the University of Mississippi, and he lives in Oxford, Mississippi during the off-season. The Giants' 21-17 victory was the second NFL championship for this team in the last 4 years. Eli Manning began the game by completing his first 9 passes, which was a new Super Bowl record, and he was named the most valuable player of the game. He became the 5th player in NFL history to win multiple Super Bowl Most Valuable Player awards. During the regular season, Manning threw for 4,933 yards and 29 touchdown passes, including an NFL record of 15 touchdown passes in 4th quarters. He also led 6 game-winning drives that allowed the Giants to overcome deficits in the final stage of their games. Manning and his wife Abby have supported many worthy causes and have made a strong commitment to the health and education of young people in Mississippi. They've made a pledge to raise $2.5 million for the Eli Manning Children's Clinics at the Hospital for Children in Jackson, Mississippi. And they've also donated $1 million to start the Ole Miss Opportunity Scholarship Program, which helps children in Mississippi with special financial needs to have the opportunity to attend college. Manning has served as a member of President Bush's Council on Physical Fitness and Sports and is active with many other organizations such as the March of Dimes and the American Red Cross. His commitment to volunteerism and national service is very impressive and worthy of high praise. Madam President, I'm very proud to congratulate Eli Manning and the New York Giants as Super Bowl champions.
Madam President.
The Republican leader.
Throughout my Senate career, I've spent a lot of time defending the First Amendment. Most of it I spent defending one particular clause of that amendment, the one relating to the right of free speech. But recent events have shown, quite unexpectedly, the urgent need to defend another clause in the First Amendment. I'm referring, of course, to the right of free exercise of religion. Make no mistake, the Obama administration's decision to force religious hospitals, charities, and schools to comply with a mandate that violates their religious views is abhorrent to the foundational principles of our nation. No one in the United States, no one, should ever be compelled by their government to choose between violating their religious beliefs and being penalized for refusing. Yet that's precisely what this mandate would do. 1 out of 6 patients in America is treated at a Catholic hospital. Catholic Charities is the largest provider of social services to poor children, families, and individuals in America. The Catholic Church runs the largest network of private schools in this country. These institutions have thrived because they've been allowed to freely pursue their religious convictions in a country that, until now, respected their constitutional right to do so. But this ruling should send a chill up the spine of people of all religious faiths, and even with those with no faith at all. Because if the state, in this case the federal government, is allowed to violate the religious rights of one religion, then surely it can violate those of others. If the rights of some are not protected, the rights of all are in danger. Isn't that what history clearly teaches? Isn't that what the Constitution is all about? The Obama administration has crossed a dangerous line. The founders knew that the right of religious belief is inviolable. They gave this God-given right the pride of place they knew it deserved right there in the First Amendment, so that Americans would never have to fear its loss. Unfortunately, because of the actions of this administration, Americans now do. This is a huge mistake that I hope the administration is currently reconsidering. And if they don't, Congress will act. The First Amendment rights of the American people must be protected. And those of us who recognize the fundamental importance of religious freedom to our nation will see to it that it is respected by this government and restored in full. Madam President, I yield the floor. I suggest the absence of a quorum.
Clerk will call the roll.
Mr. Akaka.
President,
from Missouri.
I ask that the quorum call be dispensed with.
Without objection.
I want to talk about this recent HHS directive to faith-based organizations on health care, Madam President, and suggest that it's exactly the kind of problem that many of us were concerned would develop when the government said it was going to take a greater role in deciding what health care would be like, who would make health care decisions. In this case, what kind of insurance you could give your employees if you're a religious organization. There are several pieces of legislation that might deal with this issue. My guess is there'll be several more unless the administration itself deals with it quickly and withdraws the position they have taken, which is that faith-based institutions would have to offer health insurance policies that violated their faith principles. It is a fundamental First Amendment right of Americans to have the ability to pursue their faith-based principles. In the Religious Freedom Restoration Act of 1993, passed by Congress that was a majority Democrat in both the House and the Senate, signed by President Clinton, it appears to me very clear that this is an intrusion that the law itself, as well as the Constitution, does not allow. And one of the most objectionable things about the White House position, the administration's position, is that we want you to change your principles, but we're going to give you a year to accommodate that change. Now, principles based on faith cannot be accommodated in a year. In fact, they shouldn't be accommodated in a lifetime. They are exactly that. They are principles based on faith. And this is about institutions that run hospitals, that run schools, that run daycare centers, that run all sorts of things under the umbrella of the mission of who they are. And this is about how their employees relate to them as providers of health care insurance and the kind of insurance they provide. This is not about just anybody you might run into. This is someone who's chosen to work for one of these institutions. This is someone who's chosen to affiliate themselves with one of these faith-based organizations. And clearly, the Catholic bishops are outraged by this. I've got a letter here from Bishop Carlson in St. Louis that was read in Missouri churches last week talking about this, and it says, in so ruling, the administration has cast aside the First Amendment to the Constitution of the United States, denying the Catholics our nation's first and most fundamental freedom, that of religious liberty. And as a result, unless the rule is overturned, we Catholics will be compelled either to violate our conscience or to drop health coverage for our employees and bring about the consequences for all in doing so. The administration's sole concession was to give nonprofit employers like hospitals and universities, which do not currently provide such coverage, the coverage that the administration was demanding, that's not in the letter, do not currently provide such coverage, 1 year in which to comply. I've got another report from the chief of Catholic military chaplains who wanted to send a letter to be read, who initially the military said couldn't be read. The United States Army said that the letter written and sent by the the Archbishop in charge of Catholic military chaplains could not be read in services. And after a meeting, after a discussion with the Secretary of the Army, that was changed, but only apparently when some of the letter was agreed would be taken out. Now, this is way over the line of where the government should be. Unfortunately, it's exactly the line that many of us feared would be crossed whenever the government begins to think that the government is the person to make health care decisions, whether that's the decision that you and your doctor should be making between the two of you, or the kind of insurance you and your family choose to have, or in this case, the kind of insurance you and the institution you represent chooses to offer to the people that are working there. And this is wrong. I think people know it's wrong. This is something that cannot be allowed to stand, and I'd like to turn to my friend from New Hampshire to talk about this with me for a little bit.
Well, thank you, Madam President. I certainly share the concerns of my colleague from Missouri, and I share the concerns of my constituents in New Hampshire and citizens across this nation who see the recent rule issued by the administration for what it is, an unprecedented, unnecessary affront to religious liberty in our country. And I'd like to say at the outset that this issue isn't limited to the Catholic Church. The administration's new health care mandates on religious institutions impact all religions. And, Madam President, religious freedom is a foundational American right enshrined in our Bill of Rights. The First Amendment to our Bill of Rights makes clear that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Unfortunately, I see the administration chipping away at these bedrock freedoms as it engages in a troubling pattern here with respect to this rule. And I think that we saw that the President's new mandate on religious institutions highlights the deep flaws in the health care bill. This unconstitutional law was moved through Congress and signed by the President 2 years ago without the type of due consideration, transparency, or accountability we would all expect. And we've been suffering the consequences since. And it's highlighted with what we see with these recent mandates from the Health and Human Services. I'd like to share some of the concerns that my constituents have raised about these mandates that were recently issued by Health and Human Services. There's a letter that I received this week from William Edmund Fahey, who is the president of Thomas More College in Merrimack, New Hampshire, and he says this: to condition the availability of medical benefits upon a community's willingness to violate a cardinal teaching of its faith effectively prevents the full practice of its religion and thus again violates the free exercise of a constitutional liberty. He pleaded with our delegation, the New Hampshire congressional delegation, and he said, I hope that you will see that the mandate undermines the Constitution, compromises the integrity of the government, and abuses the foundational principle that free associations form an essential part of the social fabric of the United States. We're fortunate in New Hampshire to have a number of very effective Catholic institutions and organizations. We have the Catholic Medical Center in Manchester, who serves so many in the Manchester community and surrounding areas. The Catholic Medical Center has also expressed concerns about this mandate, saying it would force us to offer services that were against our ethical and religious directive or force us not to offer insurance altogether. They added, neither are acceptable options, and the government should not put the Catholic Medical Center or any other Catholic organization who does such wonderful work in the state of New Hampshire and throughout this country in this position. The president of one of our great colleges in New Hampshire, St. Anselm College, President Jonathan D. Felice, said this: in a country and a state that values and respects individuals' rights to exercise their religious beliefs and live according to their conscience' best lights, it is simply appalling to think that this mandate is anything other than an unprecedented incursion into freedom of conscience. I've heard many concerns from my constituents, and I would hope that Health and Human Services would stop what it's doing right now, this mandate that places religious institutions in this impossible position and with this impossible choice of violating their core beliefs in order to comply with a mandate or dropping employee insurance coverage altogether. We should not be putting these organizations that do great work throughout this country in that position. And again, this isn't an issue that just applies to the Catholic Church. This applies to all religious institutions. And I would ask my colleague from the state of Missouri, as a result of our concerns about the actions of the administration, we have offered legislation to address this. And what does that legislation do in order to make sure that this mandate does not go forward?
Well, I think that's a good point, and I'd also like to say that this is not about just one set of religious beliefs. Now, the current discussion is about specific items in a health care plan, but there are lots of faith-based groups that have different views of how you deliver health services, working on these issues for some time now. I've met with a lot of these groups, and this is an issue of conscience. Whether it's the Catholic Church, the Christian Science Church, the Seventh-day Adventist Church, the Baptist Church that I'm a member of, there may be different views of this, but the views are not views that can be put forth by the government, and that becomes the government view. You know, there was a recent Supreme Court case, a school, Hosanna Tabor Academy versus Equal Opportunity Commission, where the court voted 9-0 that faith-based institutions have privileges that others do not have because that's what makes them faith-based institutions. The hiring decisions, the firing decisions, the workplace decisions are different because if they're not different, it's just another school or another hospital that might happen to have a theology department or might happen to have a chapel once a week. That's what it is. So we've, Senator Ayotte and I and others, Senator Rubio, have worked on various ways to approach this. We've offered a bill some weeks ago now that would on these issues of conscience that would create a respect for rights of conscience. The Respect for Rights of Conscience Act, which was drafted early last year, has the full support of the major groups that are concerned about these conscience issues. The Christian Medical Association, the Becket Fund, and others have said that we need to be concerned about these issues, whether it's a hiring decision now or now a health care decision. And what do we do to protect health care providers and insurers, including purchasers, from being forced to violate their own principles by buying a policy or offering a policy that provides things that they don't believe in their faith group are the right things to offer. I saw one of the President's advisors early this morning beginning to back away from this and saying, well, maybe the 1 year, suddenly this 1 year has become, we're just seeking information during this year. That's not what they were doing at all. What they were doing was saying, you're going to comply with this rule, and we're going to give you a year to figure out how to compromise your principles in a way that applies, and that's a wrong thing to do. And so whether it's the Respect for Rights of Conscience Act or other legislation, if the administration doesn't take care of this administratively, I believe it will be taken care of legislatively. When you've got bishops, when you've got church leaders, when you've got people that have spent their life dedicated to hospitals and schools and other institutions that reflect their faith principles, you can't just suddenly decide that those don't matter or they can be changed in a year. They also will need to have some legal cause of action just to pursue this, just like the Religious Freedom Act in 1993 created cause of action. You can't go in and have an unreasonable incursion on the faith beliefs of people under the First Amendment. No matter how good you think the cause might be, it's not good enough to violate that fundamental principle. Senator Ayotte has had lots of contact from our side. I think many of us have. You know, last week, if you were in a military service, you might have heard one of these letters read. And I just saw the line that had to be taken out of the letter, apparently, that the Army wouldn't otherwise was standing in front of, but was read in the other services, was the line that said, we cannot, we will not comply with this unjust law. When the government begins to tell people to do things that violate their faith principles, the government has gone too far, and I yield back.
The senator from Maryland.
Madam President, what is the parliamentary situation?
The majority controls the time until 6, and senators are limited to speak for up to 10 minutes.
Thank you very much, Madam President. I claim 10 minutes of the Democratic majority time, and I come to the floor to speak about women's health. And I come to speak about the issue of prevention. And I come to talk about the fundamental. I want fundamentally everybody to remember what we debated and what we did in the health care bill. For the first time in a long time, our nation is talking about women's health. Boy, am I glad to hear that. It's most of all been going on the morning talk shows and in our front pages of our newspapers. But unfortunately, too much of the conversation isn't really about women's health. It's politics disguised as women's health. Now, what should we be talking about when it comes to women? We should be talking about what are the top killers of women. Cancer, that dreaded C word of breast cancer, cervical cancer, lung cancer are the highest killers of women. Lung cancer, cervical cancer, and breast cancer. Then there are the silent killers of women, undetected diabetes, and then the consequences of heart and vascular disease. And what did we talk about in the health care bill to deal with that? We talked about the fact that we needed preventive services, that we believed in early detection. We believed in screening for early detection so that we could identify those consequences that would negatively impact women in terms of their health care. One of the things that we know is that for many women don't have health insurance at all. 17 million are uninsured. Women are most likely to neglect their treatment because of cost. Women of childbearing age are also even more at risk because they're in those jobs that tend to be starting out and they don't pay for health insurance. Well, we tackled a lot of this in the health care bill. I'm so proud of one of the first things that we did. We ended gender discrimination in health care. The punitive practices of insurance companies discriminated against women by charging more for women of the same age and the same health status as men. But we came together and we united and we passed part of the Affordable Health Care Act. We ended gender discrimination. Then we saw that simply being a woman was being treated as a pre-existing condition. I held a hearing that was bone-chilling about this. When we listened to how women were discriminated against and aspects that had happened to them were viewed as a pre-existing condition. In 8 states, if you were a victim of domestic violence, you couldn't get health insurance. Another bone-chilling story, which was breathtaking. A woman testified at our hearing that because she had a C-section, her insurance company told her they would drop her from their insurance plan unless she got a sterilization. That was in the hearing. She had a letter from her insurance company. We were aghast, both sides of the aisle, regardless of how you feel about some of these reproductive issues. Nobody felt in America that should happen. So the people on the committee, led by me, said we can't just have that. So we've ended discrimination against women in getting health care on the basis of pre-existing conditions. But we wanted to go farther. And one of the things we looked at was the issue of prevention. And this is a subject of great debate. Their very first amendment on the Senate floor during the health care debate was one to have preventive health care benefits. I offered an amendment. The gentlelady from Alaska, Senator Murkowski, offered a counter-amendment. Her amendment was terrific. She had every preventive service that I would have ever loved. CBO, though, scored it at something like $50 million. The CBO score sunk the Murkowski Amendment, but the Mikulski Amendment prevailed, in which we said we'll leave it to the Institute of Medicine to determine what would be some of these amendments for women. So guess what we have? In our Preventive Health Amendment, which is now the subject of such debate, such controversy, and unfortunately such misinformation, our amendment said this. First of all, if you're over 50, you get a free yearly mammogram, one of our highest risk age groups. Second, you also, if you're over 40, you get an annual well-woman preventive care visit. This then goes to the screenings that then go to the highest risk for the highest diseases we have, early detection and early screening. For young women who are pregnant, we guaranteed that they could be screened for diabetes. But also in our prevention amendment, we provided for maternity services. We provided for maternity services so those women could get proper prenatal care. Working with their doctor, we can ensure the health of the mother and the survivability and the ability to carry her pregnancy to term. We looked out for those maternity benefits. IOM also said that part of prevention, we should add contraceptive coverage. That was a recommendation not of Senator Barb, not of Senator Jeanne Shaheen. This was a recommendation of the Institute of Medicine. And why did they say that? First of all, there are over 15 or 20% of women who need to take birth control in order to deal with the medical issues around their menstrual cycles. This isn't the place to go into the biology of being a woman, but this has, for many, this is for people long before young women, adolescents, experiencing some significant hormonal problems that are not sexually active, and for people who, so it's not always about being sexually active. So this whole thing about the preventive amendment was all about birth control is so exaggerated, so overblown, so out of context with what we wanted to do. I'm shocked, and I'm just shocked. And we looked at our bill. In addition to my amendment, we included preventive services for men and women, those services that affected us both. Colorectal screening for adults over 50. That also includes prostate screening for men. It has diabetes, high blood and blood pressure screening. There's also the ability to do alcohol misuse screening, which in many instances is an undetected and silent killer, not only of lives, but of families. So you see, our major thrust, one of our major thrusts was prevention. One, maternity benefits, so that a mother could be safe and well herself and be able to carry her pregnancy to term in a way that ensured the health of both the mother and the child when the child is born. The fact that we had these other screenings, the mammograms, the prostate cancer, the diabetes, the things that are the killers of us all. Some of these will close the health disparity gap because so many of our African-American men face terrible problems with health, with high blood pressure that lead to terrible consequences of stroke, diabetes, again, rampant in our country, but particularly rampant among people of color. So that's what we were doing. So I find it troubling that instead of focusing on our preventive health services, we're focusing on birth control. Birth control was never the focus of health care reform. It was a recommendation to be included in the benefit that came from the Institute of Medicine. Now, there's another confusion out there about mandating churches against doing something against their will. I want to draw the distinction about what the bill does between mandating the provision of service and providing insurance coverage. The bill does include insurance coverage, but there is no place in the bill that mandates a religious organization provide something against their principle. That's providing the service. So if you are St. Mary's Hospital, you do not have to give out birth control in your women's health clinic. If you are Notre Dame University or Georgetown University or a Catholic women's college, you do not have to give out birth control in your student health clinic. What the Obama Sebelius regs do say is that there has to be insurance coverage available, particularly to those who are non-Catholic. And for all of us who know who go to these wonderful institutions and benefited from their services, they are non-discriminatory in who they hire. You don't have to be Catholic to teach at a Catholic college. You don't have to be Catholic to work at a Catholic hospital. You don't have to attend You don't have to be Catholic. So these institutions hire people of a variety of religious preferences. So I don't want to get into a debate on the First Amendment, but I do welcome a debate on what the health care bill did and what it intended. The health care bill, I felt, was one of the greatest social justice initiatives that I participated in the Senate. It was going to work in an organized and an effective way to make sure that we were on the road, that every American had access to affordable care. And then we removed the barriers to that, which were not only financial, but often these discriminatory practices, these punitive practices that often were directed against women in the pre-existing condition or in gender discrimination in the way they set their pricing. And the other third thing was the best care was preventive care, and one of the tools well known in the public health field were these screening tests that we work to provide, and also we turn to the eminent and distinguished people in learned societies, in this case the Institute of Medicine, to tell us, not based on politics, but to tell us based on science, what should be these benefits, and they added contraceptive coverage. So that's the history. I hope it clears up the misinformation, but we did work to move our citizens to greater health care, remove the financial and other societal barriers to getting health care in our society, and a fantastic emphasis on prevention. We've gotten off to the wrong debate and the wrong discussion. Let's get back to talking about how we improve the health care of women and how we could keep moving on our preventive aspects that not only help women, but help the men who so love us and support us, and we want to return the favor by making sure they get their screening too. Mr. President, I yield the floor.